شكرا لكم جميعا. معكم مروان النزهان. راح نكون بجلسة مع الدكتورة زهرة البرازي، محامية في القانون الدولي وعضو مجلس إدارة البرامج السوري للتطوير والقانون، متخصصة بالقانون الدولي لحقوق الإنسان وقانون اللاجئين، خاصة تحديد العلاقة بين التهجير القسري وقضايا المواطنة. وأيضا معنا الأستاذ محمود شحادة، المدير التنفيذي لمؤسسة أورانج الغير حكومية، تعمل في مجال تخفيف المعاناة وتحسين آليات الاستدامة للمتضررين من النزاع في سوريا وتركيا. بعد تشخيص ما حدث بعد الزلزال من قبل المتحدثين السابقين، أشكرهم جميعا، وخاصة بخصوص تقصير الأمم المتحدة واستثمار نظام الأسد لهذه الأزمة وتحديد احتياجات السوريين في مناطق شمال غرب سوريا. الآن الهاجس والهم الأكبر والرسالة التي نريد إيصالها لاجتماع الدول المانحة هو كيفية ضمان استدامة تدفق الاحتياجات الإنسانية لشمال غرب سوريا بدون أن تتعرض للابتزاز السياسي من قبل الروس أو النظام، أو للسرقة في حال تم دخولها عن طريق أو تحت إشراف النظام والميليشيات التابعة له. أبدأ معك دكتورة زهرة، يا ريت تشرحي لنا الآلية القانونية التي تعمل بها الأمم المتحدة لإيصال المساعدات إلى شمال غرب سوريا في المراحل السابقة، وما هي العقبات التي اعترضت هذه الآلية؟
تمام. Thank you very much, Dr. Marwan. Firstly, it's a pleasure to be here among you all and among the participants in this really important discussion. And I think I'm glad our part comes straight after the previous part where we really learned about the humanitarian needs and situation in the northwest of Syria, because it really shows what we're talking about now, really shows kind of what is at stake when things go wrong. So I think to start off, I just want to kind of go back to 2014, because this is the whole beginning of where the tools that we use now came into place. And it's really important to remember the context of the conflict in 2014, where it was very much the armed conflict was growing in intensity, and it was really kind of characterized by changing front lines, regularly changing front lines, changing governing parties, which were consistently changing. So we had a very different situation to what we have now, which you're all very aware of course, but I think it's important to remember that. And it was very problematic that all of the parties to the Syrian conflict, obviously the Syrian regime at the time included, were very much disregarding any calls or any need for humanitarian access, unimpeded humanitarian access. And so it's important to start with the context, because even though I want to give the tool, the framework that we're working under, it's really a response to the conflict, because it's really a political tool that we're talking about, not a legal tool. And so because of the situation that we were in 2014, the Security Council, the United Nations Security Council, importantly, unanimously adopted Resolution 2165, where they kind of adopted an extra legal basis for 4 international cross borders, which is 2 on the Turkish border, of course, 1 on the Iraqi and 1 on the Jordanian. And what's really important to kind of underline and note here is that this wasn't the legal basis for these openings. It was an additional legal basis for these openings. It was really to kind of strengthen the already existing laws that allowed for cross-border humanitarian access. It was a political decision to try and just structure and organize cross-border humanitarian access more than it was, because it was chaotic at the time and it was very problematic. So it wasn't the basis, which I think there is confusion on today. It was an additional international legal basis from which cross-border access could happen, and it kind of made every party to the conflict agree to do this. What's important to note as well was that the Security Council involvement in such an issue was unprecedented. So we'd not seen before the need for a Security Council resolution to allow cross-border humanitarian access in any other conflict. It was unprecedented and legally unnecessary. And I think that's really important because we feel now, I think a lot of actors, that it's a necessary thing to ensure the delivery of aid to hundreds of thousands of people in northwest of Syria, but it wasn't, and it's not happened before. This is the only time that it's happened. But although it was unprecedented, it was doing something that was already regulated by international humanitarian law. So we didn't need it, it was already regulated. Now we're in 2023, so the conflict is very different. It's what some people call a frozen conflict. It's what some people call a conflict where the governing parties are much more concrete, they're much more stable in terms of there isn't this regular changing of governing parties. So even though it's, you know, what was a good idea in 2014 and what every party thought it was a good idea, it's clear now that in 2023, this security resolution very much has, instead of helping international humanitarian law, it's very much politicized life-saving humanitarian aid. And that's where we're at now. We have a very different conflict, and this security resolution, instead of allowing, it's politicizing. Before, we used to have the resolution being updated every year, annually, without much discussion, without much problems. Now we need to do that every 6 months. Veto has meant that 3 of the 4 borders have been closed. Effectively, what this has done has crippled attempts to engage in proper programmatic cross-border aid responses. And we all know how a lot of the humanitarian organizations, instead of being able to focus on delivering aid, they're now busy trying to do advocacy to ensure that the resolution is reopened after every 6 months. So it's very much been like a politicization of access to humanitarian aid, which wasn't even needed. And what it's also done is it's confused the issues. So whether it was legally necessary or not, we have opened the door to a lot of other challenges and confusions about where a resolution is needed for aid and humanitarian access cross-border. And the obvious example to that is the earthquake, where we have a resolution that's functioning, but suddenly a new additional measure of asking the request of the regime of whether humanitarian access and another kind of emergency response could be done or not. So we're opening up levels of requirements which are not necessary under international humanitarian aid. And it's really important to note this because it's not something that's necessary at all. What we have is sufficient. And even the UN has explicitly, this isn't a political reading of the situation. The UN has explicitly said that the Syrian regime has been arbitrarily denying consent for all sorts of very legitimate humanitarian relief operations where consent isn't needed from any party to the conflict. And they, you know, quote, have said that this denial has been arbitrary and unjustified. So they themselves have called this kind of consent unjustified, and it's not needed under humanitarian law to provide humanitarian access. So that's kind of the framework, the very arbitrary framework that we're working under when we're looking at humanitarian access.
دكتورة زهرة، ضمن قوانين الأمم المتحدة كيف يمكن ضمان تجاوز العقبات اللي واجهتها دخول المساعدات الإنسانية إلى سوريا في المرحلة الماضية، بحيث يتم دخول هذه المساعدات دون التعرض للابتزاز من قبل النظام أو الروس ضمن قرارات مجلس الأمم أو تعرضها لابتزاز أيضا من الميليشيات التابعة للنظام.
Yeah, perfect. So I want to kind of start from the conclusion here, where I think it's important for us to, as civil society, as humanitarian actors, to change our thinking in our advocacy with the fact and the sentence that states, NGOs, UN agencies can legally and logistically deliver aid to Syria, to Northwest Syria, without the need for further resolution. And the title of this, or one of the questions of this panel, was how do we get around the cross-border conundrum? And I think it's really important to know that legally there is no conundrum. I think that's what we need to understand as humanitarian actors. And this was even the case, this isn't a new reading. In 2014, lawyers and judges came together and said, this resolution is not needed, and there is no point to it, because access and therefore has gone from being key operational prerequisite, very misunderstood, instead of a humanitarian need and necessity under international law. So I think getting away from the politics is kind of highlighting that what's being called as legal is not legal, it is politics. So I think we need to first do that. We need to start using international humanitarian law kind of language a bit more. And I'll send around a document that goes through a lot of detail in terms of what international humanitarian law is relevant here, if needed in terms of advocacy. But it's really important to know that humanitarian assistance is lawful for states and UN agencies under the treaties that the Syrian regime itself has ratified. So we're not talking about in any way going against sovereignty or going against what we call territorial integrity. The Syrian regime itself has ratified the conventions which we are utilizing to show that parties to the conflict, whether direct parties or whether broader parties, have no say in humanitarian access. Permission is not needed from the regime or any other party. There's also customary international law, where custom shows and is concrete in the fact that permission is not needed and humanitarian access cross-border needs to be done without the need for every 6 months a resolution to be adopted or to be expanded. The International Court of Justice, which is very much the UN's principal kind of legal body, has confirmed that impartial cross-border humanitarian access and assistance never breaches sovereignty. So we're not talking about the sovereignty of any country that are relevant to the party. It doesn't breach any territorial integrity. Even if there were questions about its legality, the fact that huge violations of international humanitarian law are being carried out, which is leading to the requirement of humanitarian assistance, means that humanitarian assistance should be given. And then what's an important point as well is that one of the arguments that is coming about is that, we should be moving more to cross-line. And I think away from the politics of that, I think it's really important to look at what that would mean in the framework of international humanitarian law. And the realities we're seeing on the ground is that cross-line realities are far more likely to be violating international humanitarian law than what we see now with cross-border. So international humanitarian law, international human rights law, it's very, very unlikely that they're not going to be seriously violated with a move to cross-line. One of the obvious examples is kind of the well-documented aid diversion that is taking place with aid that's going into the regime areas, which was supposed to be brought cross-line. So there are so many legal arguments as to why there isn't a legal conundrum and why there would be a legal conundrum if we start moving from cross-border to cross-line. So I think there is a risk as well, and I think this is important in our advocacy, that we are developing a really problematic precedent for other conflicts. If suddenly we're requiring the permission of so many states and the influence of so many states, and a veto can stop humanitarian access, we are setting a really bad precedent which didn't exist before in any future conflicts that may come about, where suddenly humanitarian access across a border, which never required any of these things because it's legally embodied principle, is suddenly needed. That's going to send a really, really bad example and precedent for the future. And I think that's a important advocacy point as well, using these kind of excuses which don't need to be used at all. And I think this kind of, I guess really the message I want to bring across is that into the next discussion, I know, which is going to be focused on more, well then in reality, what are the alternatives, is that let's try and ensure that in these discussions, we move away from kind of our desperate need for advocacy onto you know, in the resolution and it being renewed every 6 months, and more the pressure on donors who are kind of stuck in this veto prison to use the already existing tools and legal framework that already exists to ensure humanitarian aid continues at cross-border. And I think that's kind of maybe a shift that I think is important to think about when we're looking at alternatives or kind of more long-term sustainable realities for humanitarian access.
شكرا لك دكتورة زهرة. ننتقل للأستاذ محمود شحادة، المدير التنفيذي لمؤسسة أورانج غير الحكومية التي تعمل في مجال تخفيف المعاناة وتحسين آليات الاستدامة للمتضررين من النزاع في سوريا وتركيا. أستاذ محمود، أهلا بك. أستاذ محمود.
أهلا ومرحبا.
أهلا بك.
صوت واضح؟
إيه واضح أستاذ محمود.
تفضل.
أبدأ معك بالسؤال الأول أستاذ محمود. هل المنظمات الإنسانية الدولية تعمل بالتوافق مع آلية الأمم المتحدة أم تستطيع استخدام آليات أخرى لإيصال الاحتياجات الإنسانية؟
نعم، في البداية شكرا للمركز الأوروبي للسلام ورابطة كرامة المواطن، شكرا لك دكتور مروان وللسادة الضيوف. في البداية جوابا على هذا السؤال وأكمل المداخلة دكتور زهراء قبل قليل في الإطار القانوني، واضح من الشرح الذي سمعناه قبل قليل قرار عبر الحدود هو قرار يتم تسييسه الآن، وألا هي من أولويات الأمم المتحدة إيصال المساعدات الإنسانية بغض النظر عن لا يؤثر على سلطة الدولة. هذه من الأولويات التي قامت عليها الأمم المتحدة بعد الحرب العالمية. وهذا السياق التاريخي التي سردته دكتورة زهراء يوضح تسييس عمل المساعدات الإنسانية، ومن هنا من أهم مبادئ المؤسسات الإنسانية الحيادية. فمعظم المنظمات الدولية تمتلك حيادية نوعا ما بهذا القرار، فهي تستطيع أن تستمر بمساعداتها بغض النظر عن موضوع تجديد المعابر. لا يشك أن أهمية تقديم المساعدات عبر الأمم المتحدة هي كبيرة جدا لسوريا، وهذه من حق الناس في الشمال. وبعد الزيادة الأخيرة في الاحتياج الآن هناك زيادات إضافية على الكارثة الأساسية شمال سوريا، فانقطاع المساعدات هو له ضرر كبير وتم شرحه من قبل الزملاء. الآن المؤسسات الدولية تستطيع تقديم المساعدات، لكن بعض المؤسسات تتأثر من خلال التمويل المشترك المدمج بين التمويل الذي يحصل عليه من قبل الأوتشا والتمويل الذاتي من قبل هذه المؤسسات. فهناك تأثير جزئي على المؤسسات الدولية في هذا الجانب. طبعا وانقطاع التمويل عبر الأمم المتحدة وتحويله إلى مناطق النظام له آثار كارثية كبيرة على التمويل الإنساني بحد ذاته. نحن عندما نحول التمويل إلى مناطق النظام هناك كارثة كبيرة يتعرض لها هذا التمويل، ليس فقط عدم حيادية النظام بتوزيع المساعدات بشكل عادل أو التجاوزات التي يقوم بها النظام، هو يتعامل مع الكلفة المالية لهذه المساعدات حسب صرف البنوك التي هي موجودة عنده بسرعة صرف البنك المركزي، فتفقد المساعدات أكثر من نصف أو أكثر من 60% من قيمتها مباشرة عند تحويلها كأموال إلى مناطق النظام، فبالتالي هو يصرفها وهو يكسب من سعر التصريف فيها. فأي مساعدات ستأتي إلى الشمال عبر الخطوط الكروس لاين ستذهب نصفها في فرق التصريف. عدا عن ذلك وعندنا مخاوف كبيرة وتجارب سابقة مع النظام بالتعامل مع الأمور الإنسانية. لهذا السبب علينا التفكير فعليا بموضوع انقطاع المساعدة. طبعا تأثير، هناك نقطة أود أن أشير لها، يعني خلال الفترة الماضية لم نكن سعداء أبدا بموضوع تجديد المساعدات كل 6 أشهر. هذا أثر برامجيا على كل البرامج التي تقوم بدعمها من قبل الأمم المتحدة، فكل البرامج تكون على مستوى الشورت تيرم أو المستوى القصير، وهذا يؤثر على نوعية الاستجابة ويؤثر كثيرا. لكن والتهديد المستمر في القطاع وصرف أموال لموضوع المناصرة والجهد المبذول كل مرة. فعندنا الآن فعلا شبح حقيقي يخيم حول انقطاع المساعدات عبر الحدود، وهذا الأمر بالحقيقة يحتاج عمل كبير الآن حتى نستطيع أن نحرر العمل الإنساني من التسييس الذي يتعرض له في الأمم المتحدة.
طيب، أنتقل للسؤال الآخر أستاذ محمود. كيف تستطيع شرح الآليات المقترحة لاستمرار تدفق الدعم بغض النظر عن قرار مجلس الأمن؟
سأحاول أن أتكلم بهذه القضية بشكل تقني بحت. كون أن هناك سماحية للعمل المؤسسات المجتمع المدني أو المؤسسات الدولية بشكل مباشر بغض النظر عن قرارات الأمم المتحدة، هناك عدة تجارب وبدأت تظهر بعضها الآن، مثل صندوق دعم الشمال السوري AFNS، هو صندوق تقوم بدائرته شركة استشارية هي اسمها آدم سميث، وله مجلس إدارة مشكل من مؤسسات سورية ومؤسسات دولية. هذا الآن بدأ أعماله حديثا بنهايات 2022 مع بداية 2023. هذا من البدايات. الآن نحن ننصح ويعني ونرى أنه من الجيد الآن المناصرة لكل المؤسسات الدولية التي تضع أو الدول التي تضع في صندوق الأمم المتحدة في حال تحولت إلى مناطق نظام أن تدعم هذه الصناديق أو تدعم المؤسسات الدولية بشكل مباشر التي تستطيع تقديم مساعداتها في سوريا، بدلا أن تذهب الأموال إلى مناطق نظام في حال لم يتجدد القرار عبر الحدود. فهذه الطريقة الأولى. الطريقة الثانية هي كما يعني يتم الآن رائج كثيرا في أوساط المؤسسات الدولية، هو اللوكاليزيشن أو التوطين للمؤسسات المحلية. هذا كمان هو شيء قد يكون هو بديل، كون المؤسسات المحلية هي الموجودة على الأراضي التركية أو موجودة في دول أخرى لديها القدرة على الوصول بشكل مباشر، وبالتالي يتم وضع برامج لتقييم هذه المؤسسات وقياس مدى استيعابها على التحكم بهذا التمويل وإيصاله إلى المناطق المتضررة في شمال سوريا. هذه أيضا من التقنيات التي يتم العمل عليها الآن، لكن بشكل قليل جدا وخجول جدا، لكن جل التمويل هو يذهب إلى المؤسسات الأممية التي هي لها دور. نحن يعني نرغب في استمرار الدعم عبر المؤسسات الإنسانية الأممية للشمال السوري، كونه هو حق وهذا الحق ينتزع من خلال تعرض العمل الإنساني لتسييس من قبل حلفاء النظام في مجلس الأمن. وبالتالي الآلية هي الأكثر جدوى هي حل سياسي لهذه القضية، حتى لا نبقى نحن نعمل مناصرة في حلقة مفرغة وكل 6 أشهر نجدد هذا الموضوع. الحل السياسي بالموضوع في الميكانيزم اللي هي موجودة، أو آلية اتخاذ القرار في الأمم المتحدة التي هي تعرض العمل الإنساني للتسييس.
شكرا أستاذ محمود. دكتورة زهرة، أرجع لك بسؤال الآن. مؤتمر المانحين، نحن مقبلين على مؤتمر المانحين، نود توجيه رسالة واضحة لمؤتمر المانحين بشكل ما هو الصيغة القانونية التي يستطيع مجلس الأمن متابعة تقديم الدعم، أو الأمم المتحدة متابعة تقديم الدعم لشمال غرب سوريا بدون عقبات أو بدون تعرض لفيتو روسي بشكل قانوني.
I think it's important to note that under international humanitarian law, humanitarian access is necessary and doesn't need permission when it's impartial. And I think from what Dr. Mahmoud just explained, what we've heard today, what we know in reality, that aid from Crossline is not impartial. And I think it's really important to put that message across. And therefore it would be problematic under international humanitarian law to be having aid crossline, which is not impartial in any way. I think that's a really important point. And I think it's also important to note that if a solution is wanted, then a solution can be found, even if UN bodies, even if donor states want to rely on the resolution, even though the resolution isn't necessary, and they feel that there is a reliance on this is necessary. I think there could still be long-term planning. There is nothing under international law that prevents, without a resolution, that prevents the UN or donor states to be supporting civil society and localization in the long term. And so they could already be looking at changing their programmatic ways. If they themselves don't want to be doing cross-border, they can already be looking at having long-term sustainable solutions and changing their programs to ensure that they are able to support, assist, fund people who are working on the ground in a more long-term way, if they are worried that the resolution may be vetoed in the future and they may not be able to continue their work on the ground. There are solutions to that. So there are so many solutions. There is the solution legally of relying on international legal framework. If the UN donor states don't want to do that, there is the solution of long-term sustainable aid and support to those working on the ground. And there isn't a solution in Crossline, being that the amount of violations we're going to see of international humanitarian law through Crosslines, when we're looking at the lack of impartiality of the parties involved there, notably the regime. When we're looking at things like aid diversion, there isn't going to be respect of international humanitarian laws in delivering humanitarian assistance across Crossline. And I think those 2 points are very important to bring across.
شكرا دكتورة زهرة، شكرا أستاذ محمود.